ready.
Oh yay, oh yay, oh yay. The Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Good morning. This is the March session of the Court of Criminal Appeals in Nashville. As you know, we're doing this on a virtual setting this morning, and I want to thank the lawyers and everyone that's helped us to get this done. Hopefully, we will be live and in person before too much longer. The panel this morning is Judge Robert Montgomery from Kingsport, Judge Kelly Thomas from Maryville, and I am Norma McGee Ogle from Sevierville. Each of you will have 20 minutes per side for your arguments. If you would like rebuttal time, please let me know how much that would be before you begin your arguments. Ms. Lindsay, I believe we're ready for the first case.
State of Tennessee versus Derrick Himes.
Good morning, Your Honors. I am Patrick McNally. I have the pleasure of being here on behalf of the appellant Derrick Himes. Mr. Himes was convicted at a Rutherford County Circuit Court of 3 counts of rape of a child under the age of 13 and 3 counts of aggravated sexual battery. He received from the trial court a aggregate sentence of 33 years at 100%. There are 3 issues raised in the briefs for the appellant's brief for the court's consideration. The first one is a very difficult issue for any appellant to prevail on, and that is a challenge of insufficiency of the evidence. I'm reminded very, very well of this court's admonition at times to me about sufficiency, that this court is here to correct errors and not necessarily to retry a case. However, there are significant insufficient factors in this particular case that warrant this court's review of the evidence. I am very aware of the standard set by Jackson versus Virginia, State versus Vasquez, and that State versus Elkins tells me that I have a very high burden because my client has the presumption of guilt now, not the presumption of innocence as we review this evidence. But that segues into the second issue, which is about evidence that came in during the testimony of the child, and I'll call her AB. The state calls her the victim. I'll refer to her as AB because at the time she was a minor, and to protect her privacy, I'll refer to her as AB, or occasionally I'll refer to her as the victim, I think. But there were certain questions asked by the prosecutor that bolstered the child's testimony, as well as was designed to draw the sympathy of the jury. For instance, she was asked about what had happened to her sister, and her sister had been murdered over in Cannon County, adjoining to Rutherford County. The prosecutor went on and asked and said, well, how did that make you feel when you were in the Williamson County jail and unable to attend her funeral? And she said, it made me feel very bad. Obviously designed to elicit the jury's sympathy and completely irrelevant under Rule 402. But and there are a number of other questions that were asked of the witnesses that I'll get to in a moment when I address that issue. But what I'm trying to point out at the beginning here is that the insufficiency of the evidence cannot be examined without considering the improper questions that were put to the witnesses and the witnesses allowed to bolster the child's testimony as well as draw sympathy for her. And if I didn't mention, I would like to leave 5 minutes for my rebuttal argument. The third issue is in regards to the sentencing by the trial court of consecutive sentencing. Mr. Himes received 25 years for the rape of a child and 8 years on the sexual battery charges. The trial court ran them consecutive, applying several of the factors that are in the sentencing statute. The one that is of particular concerns for me is the fact that the trial court said that it was considering the span of time from when the alleged assaults ceased to when they were discovered, not as this court's case law has held that the span of time to consider is the duration of the alleged assaults. Now, you may say, and I know the state will say that, well, there were several other factors under the sentencing statute that would permit consecutive sentencing. The concern that I have in this particular case, and why I think this is prejudicial error, is the fact that we don't know what weight the court applied to the various different sentencing factors that it considered in ordering consecutive sentencing. The short paragraph that the judge used here on page 13 of the sentencing transcript simply says that the defendant was the boyfriend of the child's mother and lived with them or stayed with them on occasion. Then it also talked about the time span with regard to the undetected sexual activity to be considered. And then it said that it had to consider the nature and the extent of the residual physical and mental damage to the child or to the victim here. And the problem for this court in reviewing that sentencing decision and determining whether it was prejudicial or not is that we don't know what weight the trial court put on those three different factors for ordering consecutive sentencing. But let me go back to the beginning here. The state concedes with the appellant that there were inconsistencies between the child's testimony at trial and the statements given 4 years earlier to Detective Cox with the Murfreesboro Police Department and to the Department of Children's Services investigator. Her name is Champion Richardson. But these are, now the state characterizes it as minor omissions. This is on page 15 of the state's brief, but it is not minor omissions. There are major omissions as well as major inconsistencies. In the statements to the investigators in 2012, this child says that there were 4 occasions of sexual abuse occurring to her by Mr. Himes. When she comes to trial in 2016, it expands to 6 different occasions of alleged sexual abuse. She has no sense of any order in which they occurred. She can't tell you which was first or which was second. There's just this general lumping of all 6 at the trial testimony together. And they vary as to the content of what actually happened. During her trial testimony, the young lady, was very clear in describing an incident where Mr. Himes took her and her younger sister to McDonald's, bought them lunch, returned back to the residence, and then gave them gifts. There is no mention of that during her initial interviews by Detective Cox or by the DCS investigator. And may I remind you that both Detective Cox and the DCS investigator testified that they were very careful in their forensic, in their interviews. They wanted to develop every fact that they possibly could. They're seasoned investigators. They know that if something more or something different occurs at trial, it can be used by the defense counsel. So they were trained and careful in their interview of AB. But yet this story about going to McDonald's and coming back and presenting them with gifts and clothing was never given to the investigators 4 years earlier. Another incident that was missing from the initial interviews by Detective Knox and the DCS investigator, a story about a cupcake. According to AB's trial testimony, Mr. Himes had a cupcake. He put it in his mouth, and then she began to eat the cupcake from his mouth, sharing it together in some fashion, and then forced her to have oral copulation with him. Interestingly, 4 years earlier, not a word was mentioned about the cupcake. Now, these are not insignificant omissions. These are not minor omissions. They have significant facts attached to them that clearly would have been remembered had the child been telling the truth back when she initially made her disclosures to the time that she appeared at trial. More importantly, I want to bring to the court's attention that the state goes on to say that it is not unreasonable for the stories to vary given the time frame between the first disclosure and the trial testimony. And let's put that a little bit into perspective here. 2012, AB makes her first disclosures and she's interviewed by everybody. At trial, she testified she's now 23 years old. I believe she's 16 years old at the time that she made her initial disclosures. We're not talking about an 8, 9, 3 or 4-year-old child who understandably could be confused about what happened or might not be forthcoming of everything. We're talking about a young adolescent to a young adult. Now, here's the problem with the state's argument that it's understandable for this young lady to have made some omissions when she was initially being interviewed. These stories grew, and that is an indication of fabrication. What I'm saying is these stories got bigger, they got better, they grew in number of counts, and they grew in the detail of the stories over the years. And that's an indication of fabrication, not an indication of lack of recall. Lack of recall is when you forget things over time, when you may forget to include some facts that are at trial, when you forget to testify to some facts that you remembered 4 years earlier when you were first interviewed by the detectives. What we have here is stories that are growing, much like myths or legends of some of our heroes get bigger over time. I'm reminded here just in the Mid-South, the stories of Daniel Boone and Davy Crockett that grew over the years that they were told over and over again. And so what I'm suggesting to the court is that it is not understandable or reasonable that AB would not have included some things in her first statements to the detectives. Rather, it's more suggestive of the fact that she is fabricating her stories against Derrick Himes. Now, what happened here? Both sides concede that there's no forensic evidence, and there's at least 4 years or more between the time that the alleged incidents were supposed to have occurred and when AB made her disclosures. These disclosures are were precipitated by her attempted suicide, and then she goes on a rampage of burglaries, including the burglary of her own grandmother's home. But what I want to get to is what's important here to realize is that there's no other evidence. There's no eyewitnesses, there's no confession, there's no forensic evidence, there's nothing to support AB's stories against Derrick Himes. And in fact, there's a lot of evidence that suggests that it did not happen. But what I was concerned about in this particular case was the improper bolstering of AB's testimony and the prosecutor's questions that were used to elicit sympathy for AB. For instance, on direct examination, the prosecutor asked her, "Did you try to be as honest as you could?" And of course she said yes. "Are you trying to be as honest and tell the truth to the best of your ability in this trial?" And of course she said again yes. Then the prosecutor went on to say, "Please tell the jury what became of your sister." "My sister was murdered January 15th of 2017. Where were you when she got murdered?" "I was in the Williamson County Jail." "Did you request to go to her funeral?" "I did." "And how did you do that?" "They told me I was an aggravated criminal and that I was a flight risk." "How did that impact you?" How did that impact you? Had no bearing whatsoever on her credibility or on the facts of this case. "Very hard. I didn't get to say goodbye to my little sister." This is in 2017, 10 years or more beyond when the alleged incidents were supposed to have occurred. But it goes on. "Since the events that we've been talking about here in a minute regarding Derrick Himes, what involvement or role has your mother played in your life?" "Not much," was the answer. "Do you know where she is now?" Now we're talking about at the time of trial, 2016, 2017 again. "She's in rehab or halfway house." Okay. "Does she claim to remember anything about that time?" "No, she says she was too high." An improper hearsay statement coming in. Unfortunately, no contemporary objection, but it was raised in the motion for a new trial, but clearly a hearsay statement being made. "And is that why you haven't been able to talk to her about these events?" "Correct. And bad memory, so I want to avoid it." That was particularly important. One thing I failed to bring up in my brief is I bring up in the brief about how it's used to elicit sympathy to develop sympathy for this young lady testifying that her mother's in rehab, that she's high. But it's important, but what I had failed to bring up was that the defense proof during cross-examination of the detectives was that they had gone and interviewed the mother. They had interviewed her, who said, I know there were never any claims of sexual abuse by my daughter against Derrick Himes, my boyfriend. There was never any indication of sexual abuse by my daughter, by my boyfriend against my daughter. They even went and interviewed the grandmother who rescued this child from her mother, who was becoming a full junkie, and lived with her for several years, who nurtured her, who raised her. And again, the grandmother said, never was there ever a claim of any sexual abuse by Derrick Himes. What this statement, what this question by the prosecutor and the statement by the child to be able to say that her mother was too high to remember anything, actually rebutted the defense proof that had already been shown to show that the investigation by the detectives indicated that there was no corroboration by any other witnesses who were present during the time frame when Mr. Himes was living with the mother. I hope I've articulated that correctly, because I want the court to understand that this not only was to develop sympathy for AB in front of the jury, but it was also an end round with a hearsay statement to rebut the proof that the defense had developed through the investigating detectives and DCS investigator, that no one corroborated this child's allegations against my client, Derrick Himes.
Mr. McNally, you're
yes,
almost into your rebuttal time.
Okay, and the point on the sentencing is very straightforward. You know, I recognize that the statute does allow the court to give consecutive sentencing, and I'm talking about 40-35-115 subsection B5. You list several different factors that the court can consider in giving consecutive sentencing. The problem here is that this court used the time span from when the incidences are alleged to have stopped to when they were later detected or when they were later disclosed as a factor to consider consecutive sentencing. And as I read from the transcript, we can't tell what weight the court used that on in relationship to the other permissible factors. Thank you, Your Honor. I'll cease at this point.
Thank you. General Watkins.
Good morning, Your Honors. May it please the court. Austin Watkins appearing here on behalf of the state of Tennessee. In this case, the judgments of the trial court should be affirmed because the defendant cannot show that he's entitled to relief on any of his three issues. First, the victim's testimony provided legally sufficient evidence to support the defendant's convictions, and her credibility was a question for the jury to decide. Second, the trial court properly admitted relevant testimony about the victim's family and her credibility. And then third, on the sentencing issue here, the trial court did not abuse its discretion by imposing partially consecutive sentences based on that statutory factor for the commission of multiple child sex crimes. And so, Your Honors, turning to this first issue regarding the sufficiency of the evidence, Your Honors are very familiar with the standard of review here. And basically, what the Supreme Court has said in State versus Elkins is that the uncorroborated testimony of a child abuse victim can be sufficient to support a conviction in these types of cases, and that in order for a defendant to prevail under the Jackson versus Virginia standard, that the victim's testimony has to essentially be patently unbelievable, that no rational juror could choose to believe the victim's testimony because it is so far-fetched and riddled with inconsistencies. And that is not what the record shows here. Instead, all the defendant can point to is very general impeachment about the number of offenses that she reported in her pretrial statement, which was about 5 years before trial, and then a couple of details that were not included in that original pretrial statement. The pretrial statement itself was not admitted into evidence as substantive evidence. It was marked for ID only and was not provided to the jury. Basically, all we know is that in her pretrial statement to the lead detective, she testified to about 4 incidents and then testified to 6 essentially 5 incidents that were elected, and then about that made up 6 different acts, criminal acts. And then the defendant's able to kind of point to 2 specific details regarding this, her, the purchase of lingerie and this, one of the incidents involving some cupcakes. And those are minor inconsistencies. That is something that's well within the jury's purview as the trier of fact to determine credibility, to weigh out whether or not this victim on the stand was telling the truth about what happened to her. And she explained very clearly that when she made her pretrial statement, she was embarrassed and that she tried to get through it as best she could. She tried to be as honest as she could in that testimony, but she also was testifying truthfully under oath and at trial. And she described how difficult it was for her to recall anytime she tried to talk about these incidents, that it was emotionally disturbing for her. The record is very explicit about her inability to even sit down and reread her statement that she had given before the trial, that she became emotionally, unstable and uncomposed. There had to be multiple recesses, I believe, for her to kind of pull herself together. And so this was very difficult. And this is not uncommon in these types of, child sex cases. And so under this very difficult standard here, this was something that a rational jury could choose to have found her credible at trial. They were presented with the information, the inconsistencies were pointed out. It was a very large part of the appellant's, defense strategy was to point out these inconsistencies that the story had evolved. But again, this was a very emotionally charged subject. It was difficult for her to talk about. And again, that it's important to keep in mind the chronological distance here between what happened. There was about 4 years between these events, and then when her first disclosure happened, and then about 5 years after that she was testifying at trial. So we're talking about a 9-year difference between when these events allegedly occurred and then the victim's trial testimony. And so, Your Honors, if you take a good look at the record here, it supports that under the constitutional standard, there was sufficient evidence to support these convictions. And so the state would ask you to affirm. Moving, Your Honors, to the second issues of the different types of questioning about the victim's credibility and her and details about her family members, in particular her mom and her younger sister. I do want to clarify here that we've got 2 different applicable standards of review. There are several questions that the appellant points to about the victim testifying about her mother and her younger sister. Those are reviewed for plain error because there was no contemporaneous objection to any of those questions and answers. Then there's a separate line of questioning, one with regard to the victim, one with regard to the lead detective, that essentially amount to questions generally about the victim's credibility. And with regard to the detective, it's specifically about, it's really a very small portion of testimony about 2 pretrial statements. And so to start with these questions about victim's family, essentially, they come in the context of the prosecutor inviting the victim to provide some background information about her family circumstances at the time of these alleged offenses. And she explains, and it's relevant to what her testimony is going to be, that her mom was unavailable because she was a drug addict and was not responsive to her struggles at the time. And her later testimony, it was very clear that there were times where she was seeking help from her mother and was either unable to find her mother in their apartment, or her mother essentially at one point when the victim tried to talk to her about what was happening became combative and aggressive towards the victim. And so it is just kind of providing context for the jury to understand why the defendant was able to isolate the victim and have lots of access to her when she was a vulnerable person, because her mother was unavailable to protect her given her addiction. And so that comes out. And then similarly, the questioning with regard to where her mother was and where her younger sister was relevant simply to show why neither of them were going to be present to provide testimony to the jury at this time. And so, again, because credibility was an issue here, the state was simply trying to get her to explain why she was going to be the only person who was going to be testifying against the defendant about what happened to her.
Well, didn't her testimony, when she was describing the events, were there events that were witnessed by her sister?
No, Your Honor. There's no indication that that was true.
Well, then what does her sister not being available at trial have to do with anything?
Your Honor, her sister could have provided some general corroboration about the nature of the defendant's relationship with the victim, how often the victim would have been left alone in this apartment with the defendant. So there's some kind of broader information that could have been relevant, that not with specific corroboration of the actual acts, but would have provided general corroboration of the time of the defendant living with her family. These kind of general general details that still provide, loose, information that the jury would want to hear to know, okay, we're talking about this was a time where there was turmoil in the home. The defendant would have been able to have access. So it's believable that these things would have occurred in this apartment, with the defendant acting as the victim's, even though he was a boyfriend, she called him her dad, and that he had this kind of relationship where he was able to take advantage of her when the victim testified about her younger sister trying to leave and spending a lot of time away from the apartment with a friend, which left the victim without her mother, who would have been high or gone, just at home with the defendant. So not specific corroboration, general
Aren't you assuming that this might have been what the sister testified to?
Well,
Is
yes.
all of this based on, it seems like assumptions?
Well, Your Honor, we don't have any testimony from the younger sister. So that is true, that this would be essentially assuming she would have been available to provide essentially what the victim kind of suggested she would have been able to provide. But these were just a couple of questions in the grand scheme of things. We're looking at them under plain error review. So we have to show a clear and unequivocal breach here, and relevance is a low standard. And then, even if these were kind of under a 403 standard, the prejudicial value was outweighed by the probative value, the defendant still has to show that there was, a substantial likelihood of an injurious effect on the jury's verdict under plain error review. This court has been very clear that evidentiary issues almost never rise to the level of plain error. And then second, he has to show, he had the burden of showing that there was not a tactical decision not to object to these couple of questions about the nature of her family and her home life. And it's very, very believable that part of the strategy was that the defense counsel did not want to, essentially appear to be badgering the victim or preventing her from sharing her story. That is a common tactical decision that we see in these highly emotionally charged decisions, where rather than appearing to try to prevent some of the story coming out from a victim, that a defense counsel will say, you know what, I'm going to clean this up on cross-examination and let this testimony come out. So under plain error review, there was certainly some probative value, and even if there was a question about that, under plain error review, the defendant just cannot show that he's entitled to relief here. Moving to these questions about her credibility, it's important to understand that the couple of questions about where the prosecutor's inviting the victim to kind of say, like, hey, were you being truthful in your pretrial statement to the lead detective? Are you testifying honestly here today? Those questions come in on redirect examination. She's already been cross-examined very heavily about those inconsistencies between her trial statement and her pretrial statement. She's also been extensively cross-examined on her lengthy criminal history. And so this court in the Tolles case, as in the state's brief, very clearly says this is not improper bolstering. There is no problem with a prosecutor asking a witness if they are telling the truth, if they are testifying, in a manner that is consistent with their oath. And that was what the prosecutor was doing here on redirect by revisiting a subject that had already been opened up on cross-examination here. And so that was relevant testimony. It's very clear under Tolles. It's not a situation where the prosecutor is trying to get her to, kind of somehow affirm the prosecutor's personal belief. I think there may have been some mention of improper vouching. This is not a vouching situation. And then similarly, what this court has explained, what is true bolstering is trying to introduce a prior consistent statement before there has been a legitimate credibility attack. And the state was not trying to introduce a prior consistent statement. So this is just not a bolstering issue. This is relevant testimony where the defendant is being given opportunity to tell the jury, I've tried to do my best in my pretrial statement to be honest with the investigators, and I'm doing my best to testify truthfully under oath today. And because of the nature of this subject matter, it's been very difficult for me here and then to talk about what happened to me. So that is relevant, Your Honors. And then on this question about whether the lead detective could testify about essentially two different pretrial statements. During cross-examination, the victim was asked about how many times she had told other people about what happened to her. And so she did that. It was brought out that she had given actually two pretrial statements to the lead detective, and the first one was not recorded. And so when the lead detective testifies after the victim, the state is getting the lead detective to briefly explain, what happened. Why were there two different statements? And only one of them was recorded. So the lead detective explains, well, the first time she talked to me, we thought we were recording it, but because of the technical difficulty, it was not recorded. So she then came back a week or two later and we redid the interview on the record. And so the detective being in the room, the state says, well, were those testimonies, the same? Were they consistent? And the lead detective says, yes, they were. So it's basically a factual assertion that the substance of both of the statements that were given, they were the same. We're essentially doing a redo of the recorded one because we unfortunately didn't get to record the first statement. And so this was not a situation where, the state was asking the lead detective to essentially encroach into the jury's fact-finding province, was not asking the lead detective to opine on the credibility of the victim at trial. It was simply just information that after it had been already brought up, why were there two statements? Was this a substantive type thing that you were trying to get into on these two different statements, or was there a very innocent explanation, which is that the recorder didn't work? And so, Your Honor, is that under the lay opinion rule, honestly, if you look at 701, it doesn't absolutely bar lay opinion testimony if that's what this is, but it just says it has to be based on the witness's personal perception, and it has to be helpful to the jury. The jury couldn't make a determination about the consistency between the two statements because only one of them was recorded. So it was just a very brief, informative statement by the detective that, yes, there were two interviews, and the second one was recorded. The first one, there was a technical glitch. They're basically the same interview. So what you're seeing in this recorded interview was largely the exact same thing that had happened very shortly before that, a couple of days before, or again, a couple of weeks. I can't remember exactly the separation there. So, Your Honors, these type of evidentiary issues here just are the ones that are subject to plain error review do not rise to the level of plain error. And then on these other questions where there was a contemporaneous objection, there's still just no error in the trial court's admission of that type of questioning and answers here. And then lastly, Your Honors, on this issue of the discretionary partial consecutive sentencing, Your Honors, the statute allows for discretionary sentencing when there are multiple child sex crimes, and there's kind of just a list of factors that the trial court gets to look at. Whether or not, it talks about, let me get the quote exactly, Your Honors, about what the statute is with regard to the time span of defendant's undetected sexual activity, the nature and scope of the sexual acts, and the extent of the residual physical and mental damage to the victim or victims, and then just generally consideration of the aggravating circumstances arising from the relationship between the defendant and the victim. And Your Honors, the appellant cites these cases that show application of this factor with regard to the lengthy time for when the abuse was occurring, but he hasn't cited any cases that say you can't apply this factor when there has been a long delay between when the events occurred and when the disclosure happened. And even if it shouldn't have been applied in this situation, the trial court did place its reasons on the record, and it explained that it was also considering the nature of the defendant being the boyfriend living with the victim's family and having access to the victim, and then specifically talked about the nature and extent of the residual and physical mental damage. And the trial court said, quote, obviously was significant with regard to that, end quote. So the record supports kind of all of those factors as well. It's very clear that the defendant isolated, groomed this victim to kind of commit these offenses, preyed on her when she was weak and vulnerable. There was some testimony from the victim that he used her status as an older sister to kind of oppress her by saying it was better that he was doing it to her rather than her younger sister. And then there's also extensive testimony, or I say extensive, there is considerable testimony that the victim only came forward because she'd attempted suicide. Very clearly residual psychological damage that she was struggling to deal with what had happened to her with this regard, and then also ostensibly contributed to her crime spree that she went on a couple of years after this as she got older. And then it's very clear from the record that she faced very difficult times in trying to testify about what happened at trial. There are several times where she has to be asked to speak louder. There are several times where she's offered a Kleenex. And then there's at least one, I think it's multiple recesses for her to gather herself so she can continue providing her testimony. So, Your Honors, under the abuse of discretion standard, the trial court's decision has provided a presumption of reasonableness, and the records are on the record. The reasons from the trial court are on the record here for this, this court to review, and there is support within the record to find application of this discretionary consecutive sentencing factor. So, Your Honors, if there are no further questions, the state would ask you to affirm these judgments.
Thank you. Mr. McNally, you are recognized.
I would like to also make sure we put this in the time perspective here. The indictment charges Mr. Hines with committing these offenses over a 9-month period of time starting in September 2007 through May of 2008. It is then 2012 before the first disclosure of any alleged sexual abuse occurs to Detective Knox. It is then another 4 years before an indictment is returned out of the Rutherford County Circuit Court in April of 2016, and another 3 years before a trial occurs. So I want to make sure we had that in the time frame. And there's a lot of unusual things that occurred during the trial of this case. It is not just that this young lady, AB, had some difficulty testifying. She actually called the victim witness between day 1 and day 2, saying she wanted to drop the charges, that she would apologize for lying during her testimony. Now, after the trial judge brought her in and talked to her, we found out that she had actually given some inconsistencies from what her memory was that were not particularly germane to the very charges themselves, but she was having difficulty. She was recognizing that she was giving different stories during the course of these events. I'm reminded of the fact that here, sometimes we need to stay focused on what our very best arguments are. There is absolutely no reason why the prosecutor should have been allowed to ask this young lady about her deceased sister and how it made her feel stuck in the Williamson County Jail and unable to attend the funeral. There is no reason why in 2016, when the trial was occurring, in 2019, when the trial was occurring, for the prosecutor to be asking this young lady, well, what did your mom say to you since she's been in rehab about these events occurring 9 years earlier? And be able to get out without an objection from the defense counsel that, well, mom says she doesn't really remember because she was too high. When mom was interviewed in 2012 by Detective Knox and the DCS worker, mom said very clearly, I never had any complaints and I never saw anything. Mom did not say that while lying in bed with Derrick Hines one night, I think he may have been fondling my daughter, as AB claims. Mom did not say that my daughter confronted me and sadly, I didn't believe her. I thought she was stealing my man after she allegedly was raped and had been bleeding. These are not things that mom simply would be too high to remember. These were incidences that if they had occurred, the mother would have been reporting them in 2012. You know, this court has some cases that say that when considering the errors that occurred during the trial, you have to consider the relative strength or weaknesses of the case. And I want to point out again that throughout the interview of Derrick Himes that he gave to Detective Knox, he maintained his innocence. And that interview was played in its entirety for the jury. And that was not an above board interview. Detective Knox, along with another Detective Jones, told Mr. Himes that there was DNA evidence that linked him. Not true. They told him that the young lady had described his penis. Not true. They told Mr. Himes that she had described his body. Not true. Throughout this, continuously throughout it, he kept saying, I didn't do this. Wow, I can't believe they're accusing me of this. And even with that final trick question, which is that the detectives use all the time in these kind of investigations, what would you say to the young lady? What would you say to our victim if you could speak to her right now? If you could, what would you say? And Derrick Himes' parting comments were, I hope they stayed in school, away from drugs and gangs. Your Honors, I would ask the court to review this in its totality, see the weaknesses of the case, the persistence of Mr. Himes' innocence, and vacate the convictions. Thank you.
Thank you, counsel. That will conclude this case, and the court will be in recess until 11 o'clock.
This Honorable Court of Criminal Appeals is now in recess.